So let's talk about the obvious problem that we've got in real estate. And once again, it's being caused by realtors overcompensating for a conversation that they simply need education around. Fair housing isn't new to any of us. The rules and laws against steering are not new to any of us. But if you don't consistently educate yourself on the things that you need to be doing to be better, just simply being better, then you're going to get yourself in trouble. And we're going to talk about that today. Do not let the new commission guidelines and the new commission changes that have been in place by the NAR because of their lawsuit to change the way that you're going to do business in a way that puts you or your client at risk. Every real estate agent knows that they have to follow the Fair Housing Act law. Period. And I say law repeatedly because you need to understand this isn't some rule or regulation. This is the law. There are financial penalties. There are huge legal penalties. There are licensing penalties. And there's jail time attached to some of this if you don't watch yourself. And clients, I'm not just talking to my agents today. I'm trying to protect my agents. But you, Mr. and Mrs. Client, can traditionally put us in these positions too if you don't watch yourself. We're not 50 years ago anymore. The way you talk to each other, the way you just simply don't know how to be nice anymore, is causing this rift in the way human beings interact. We are all legally and ethically obligated to ensure that we have fair treatment and equal access to housing. Failure from a real estate professional's angle to comply with these types of laws violates an agent's fiduciary responsibilities towards a client and violates a protective class. What we're going to talk about today is going to tackle fair housing. We're going to talk about how the real estate industry is prohibited from these type of discrimination activities. I'm going to tell you about the enforcements. I'll scare you a little bit with some statistics, and I'm going to help you comply and make you understand that there is simply a better way to do your job without steering in the wrong directions. Little backstory about the Fair Housing Act. It's United States only federal law that was created as a part of the Civil Rights Act of 1968. It was created to simply prohibit housing discrimination during the sale or the rental or the financing processes that are put into place to accommodate housing. The law applies to single-family homes, apartments, condos, and regardless of whether they are sold or rented, they are covered by these laws. The law applies also to mortgage lenders, mortgage lending practices, the insuring of those properties, and the marketing and advertising for housing. There is a nice list of protected classes, and I need you to understand how non-specific they are so that you appreciate that just about everybody is included. People with disabilities, race, sexual orientation, color, national origins, religion, and family status are all documented and set protected classes by the Fair Housing Act. 1974 and 1988, it was amended to include some additional groups of protected classes, and these you need to understand go a little bit deeper and beyond that. But the federally implemented laws that act as a baseline for these states, and I mean all 50 of them, have local governments to create the laws surrounding the Fair Housing Acts as well. So depending on the state you're in, fair housing real estate laws can also be expanded to protect additional classes on top of that. And again, depends on what state you're in, but a federal law was taken to a state level, was taken to an immediate local level. There is now gender expression, gender identity protections, citizenship status, partnership status, so not just single or married. There are people that live together. There are people that still have children together that may have a different partnership availability to them. Lawful occupation, ancestry, sources of their income are protected. Age discrimination is protected against. domestic violence, victim status, genetic information, marital status, medical condition, sexual orientation, military and veteran status, primary languages that are spoken, and in some states, criminal background is also protected by these extensions of those same acts. So what is absolutely prohibited, Alex, and how does this protect me as an agent from getting accused of steering or directly violating any of these acts? You must, as a real estate agent, and as a consumer for that matter, you must understand the Fair Housing Act and the state-specific laws. They are aimed to protect your business and the way you do business and the clients that you do business with. And unfortunately, it is a horrible scenario that the bad that have continuously done this have forced us to have to put these type of rules that should be just logical to the average person. But these real estate discriminatory prohibitions, these are in place to make sure that it covers all housing, and it covers landlords as well, and agents and lenders alike. So let's talk about a few things that will immediately get you in trouble. From a landlord or property owner perspective, if you are refusing to sell or rent housing to any of these classes because you personally have a bias, it's illegal. If you are setting different terms or conditions for the housing that you are selling or renting, because if a certain person in one of these classes shows up and it's something that you have a bias against, also completely illegal. For not making reasonable accommodations for people in properties and tenants, completely illegal. Denying negotiations because you don't want to negotiate with people that are in any of these protected classes, again, that you have bias towards, completely illegal, not allowed. Real estate agents, hear me, these are specifically for you. If you're including a preference in your advertisements for or against any of these protected classes, it's a violation. You will absolutely get in trouble for it. If you're using exclusionary language to deter so that people don't actually inquire about availability in the MLS or outside in your independent advertising, absolutely you'll get in trouble for it. If you're encouraging or deterring clients from a particular neighborhood or a particular type of property, then you will absolutely get written up for these types of things. Potentially lose your license, potentially by the level at which that you committed this crime. There are penalties fiscally and jail time associated. Lenders, and lenders are important to this entire puzzle as well. Without them, most people do not have access to the financing they need to buy a piece of property. So lenders, if you're refusing to do mortgage or financial assistance for a home based on any of these protective classes, you can't do it. There is no gray area, by the way, to any of these. If I can, for 1 second, make the assumption or make the presumption that this was done against a protected class, you need to make the change immediately. Lenders, if you are declining to provide information regarding loans to create different terms and conditions of services, also, this is a direct violation of the Fair Housing Act. There's always exceptions to all of these laws, and certainly there are a lot of people out there that are also taking advantage of the broad scope of these classifications in hopes of getting a quick payout. And you have to be careful about that too. But the thing that you do need to be most aware of, Fair Housing Act exempts owner-occupied single-family buildings with less than 4 units, for example. There are some additional practices that are in place, but these are well written. A great example is 55 plus communities, for example. They can absolutely, as long as they've done the proper paperwork, they can have their building exempt to people that are of a lesser age than 55 if they have deemed their property a 55 plus community. Now, not just deemed it by hanging a sign in a window. There are local and state jurisdictional paperworks that they do need to fill out, that they do need to have classified, and they've got to have additional concessions for the residents in place to make sure that as a 55 plus community, they're taking care of all of their members equally as well, so that those senior citizens don't get taken advantage of too. Enforcement of the Fair Housing Act is probably a lot easier than you think, and you need to be careful here. The Fair Housing Act empowered the Department of Justice to file lawsuits against individuals or organizations that they feel are in a pattern or practice of discrimination. So again, sure, you might get accused of it once and you might get away with it, but if they detect that this is happening again, and that there are several, if not the same, that are accusing you of these practices, believe me, you will get shut down while they do a full investigation really quickly. And as a brokerage, we have an obligation to stop you from doing business while these investigations are taking place. We must fully cooperate. So please don't think that I have an accusation, so now that that's going on, I'll go ahead and continue to do business. No, you are halted from doing any further business while the Department of Justice finalizes an investigation. The U.S. Attorney General will ultimately decide what will constitute a matter of general public importance, but I'm going to tell you, the paperwork is easy. They can do it online. It is simple for them to get these things filled out and ran up the flagpole. So watch yourself. And hopefully this class will give you some more insight into the things that you might be getting a little close to the line on that you may want to start changing your practices on. The Department of Justice under these acts can sue under the Fair Housing Administration for systematic mortgage discrimination, or if a group's denial of rights raises public concern, they can even raise criminal charges when discrimination involves force or threats. Individuals, and these are our clients, individuals who believe that they have been discriminated against can directly file a complaint with the U.S. Department of Housing and Urban Development, the HUD, or they can initiate legal proceedings in a federal or state court. The Department of Justice will even provide them legal representation if necessary. So please don't think if they are in a protective class that they may not have access to the funds for a lawsuit. The Department of Justice will fully and financially support their claims to make absolutely sure that they are represented appropriately. Look, this is all scary stuff. Ultimately, what we're trying to tell you is that you need to be more self-conscious and more aware of your business practices and the fair practices that you should have in place. If someone was to go as far as to file a discrimination complaint against you or the company you work for, the HUD will be responsible for conducting a full, comprehensive investigation. If their conclusion is unsuccessful, certainly the HUD will determine whether any federal laws have been violated. But if there is reasonable cause to believe that any of these regulations have been violated, the HUD's going to issue a charge of discrimination. You and your business will be labeled with this. You will absolutely lose your license and probably have much difficulty getting hired in other places where these types of laws would be a problem for you to do traditional levels of sales or business in front of clientele. There's a reason that these things are in place, and these things have been tried and tested to keep steering practices from occurring.